Welcome to a deep dive into landmark Indian arbitration cases, an essential resource for anyone interested in commercial dispute resolution. This module is designed not only for legal practitioners, but also for students in law schools, business schools, and professionals in corporate training programs. By studying these 7 landmark cases, you will gain practical insights into legal reasoning, dispute resolution strategies, and the real-world challenges faced by businesses. Case-based learning bridges theory and practice, making complex legal concepts accessible and relevant. Each case study follows a structured approach: commercial context, procedural journey, legal issues, and managerial implications. Together, they provide a comprehensive foundation for mastering arbitration in India. Case Study 1. BALCO versus Kaiser Aluminium Technical Services, 2012. This Supreme Court decision fundamentally changed how India approaches foreign-seated arbitrations. An Indian public sector company contracted with a foreign entity for industrial equipment supply. The contract chose London as the arbitration seat, but Indian law as the governing substantive law. When disputes arose over delays and performance metrics, the critical question emerged: can Indian courts supervise arbitrations seated outside India? The Supreme Court held definitively, Part 1 of the Arbitration Act does not apply to foreign-seated arbitrations. The seat determines supervisory jurisdiction. This seat-centric approach aligned India with international best practices, providing certainty for cross-border commerce while limiting local judicial recourse. Case Study 2. ONGC versus Saw Pipes, 2003. This case expanded the public policy exception for setting aside domestic arbitral awards. The Supreme Court ruled that patent illegality apparent on the face of an award constitutes grounds for setting aside under public policy, a decision that sharpened judicial review of arbitral awards. Case Study 3. Amazon versus Future Retail, 2021. This landmark decision embraced emergency arbitration, allowing rapid interim relief in commercial disputes. The Supreme Court confirmed that emergency arbitrator orders under institutional rules like SIAC are enforceable in India, aligning with global commercial practice. Case Study 4. Delhi Airport Metro Express versus Delhi Metro Rail Corporation. This infrastructure arbitration tested the system with complex technical evidence and public-private partnership disputes. Courts showed restraint in reappreciating technical findings, emphasizing the finality of arbitral awards and the importance of expert evidence in infrastructure disputes. Case Study 5. Renusiga Power versus General Electric, 1994. This pro-enforcement decision established narrow public policy grounds for resisting foreign award enforcement. The Supreme Court limited public policy objections to fundamental violations of Indian law, interests of India, or justice and morality, making enforcement more predictable for cross-border transactions. Case Study 6. Afghans versus Cherry and Varkey Construction, 2010. This decision mainstreamed court-annexed ADR, establishing guidelines for referring disputes to mediation and conciliation. The judgment recognized that mediation can preserve long-term business relationships while resolving disputes more efficiently than traditional litigation. Case Study 7. NHAI Conciliation Panels. This innovative approach unlocked thousands of crores in stalled highway disputes through structured settlement processes. Technical and legal experts facilitated settlements between NHAI and contractors, demonstrating how institutionalized conciliation can resolve sectoral disputes at scale. These case studies are powerful tools for interactive learning. Educators can organize group discussions, mock arbitration sessions, and role-play exercises to help students experience real-world dispute resolution. Teachers and trainers can use mock arbitration exercises to develop critical thinking, negotiation, and legal drafting skills. These activities bridge the gap between legal theory and business practice. Students can present their findings, debate legal strategies, and reflect on the practical lessons from these landmark cases. This approach prepares them for real challenges in the legal and business world. Whether you are an educator, trainer, or student, apply these lessons in your academic and professional journey. Use these case studies to master arbitration and shape the future of dispute resolution in India.